Now to the big day tomorrow. The President of the Court of Appeal, Justice Monica Dompa-Mensem, is expected to formally unveil members of the Presidential Election Petition Tribunal that will adjudicate on all petitions filed against the declaration of Senator Bola Tinubu as a winner of the 2023 presidential elections. A total of 5 petitions, well, 4, but 5 were filed originally against the victory of President-elect Senator Bola Tinubu in that election. So let's run you through some of them. Well, the Action Alliance, AA, was the first to petition the declaration of INEC. A faction of the party actually filed a lawsuit, based its argument on the premise that INEC failed to upload the name of its authentic presidential candidate, Solomon David Okanigwan, to its portal for the presidential poll. Ironically, it's a case of first in, first out, as the Action Alliance has filed to withdraw that case that is expected to be decided on tomorrow. So we can strike that out effectively. So 4 left. The next is the Action People's Party, Petition, the Tribunal. The case has, of course, these people, Senator Bola Tinubu, the APC and INEC as respondents. Then, of course, the Labour Party. The Labour Party has its petition, and Mr. Peter Obi, of course, with INEC, Senator Bola Tinubu, Kashim Shettima, his vice, and the APC as the respondents. The third one is that of the Allied People's Movement, the APM, and it has this list: INEC, APC, Bola Tinubu, Kashim Shettima, and adds Kabir Masari. You might remember the placeholder conversation. Yeah, that's also in this case. And finally, the People's Democratic Party, PDP, and Atiku Abubakar, again, has the INEC, Bola Tinubu, and the APC as respondents in that very case. So it's billed to be perhaps the biggest election petition this country has seen. It's building up to that one. So let's help you understand what will be playing out in the next few weeks or months, depending on how it goes. We have joining us in the studio 2 hefty guests, really. I'm literally facing a panel right here in the studio. Mr. Kayode Adelola is a senior advocate of Nigeria. He's right here in our Lagos studio, and senior advocate of Nigeria, Adeleke Agbola. Gentlemen, thank you for joining us.
A pleasure to be here.
As I said, I feel like I'm in front of a panel. So I'm just going to listen a lot, and I'm sure a lot of Nigerians also want to listen and understand. So let's start with your thoughts on this voyage we're about to embark upon. What does this mean for Nigeria and its democracy? I'll begin with you, Mr. Adelola.
Let's put it this way. We have a situation where members of the electorate are very anxious about what the outcome of the election petitions will be like. A lot of people do not know what the dynamics of election petitions are like. They don't know what the rules are. But I can tell you that we are in for a period which is definite. The Constitution says you have a maximum of 180 days within which the petition must be heard and judgment delivered. And 180 days begins to run from the date the petition is filed. So how many days do we have? Once we begin to discuss how many days the respondents have had to file their responses, then we have the pre-hearing session, which will commence tomorrow. And the pre-hearing period will go on for a period of about 14 days. A decision will be taken regarding maybe electoral interlocutory issues, how witnesses will be lined up and taken, if there are documents which they want to look at and determine whether there are issues concerning them. They want to then have timelines, because each party will be given the same amount of time within which to prepare their cases or to present their cases. So this is what members of the public should know would happen. So 180 days is the maximum. It is possible that this whole process will go on for less than 180 days, but the chances are very slim, because once the witnesses have been taken, the evidence taken, the cross-examinations are taken by the respective counsel, including INEC, then we're going to have the counsel representing the parties filing the briefs of argument. Then the election tribunal itself requires ample time to look at this evidence, a lot of the bundles of papers before them, the oral evidence given by the witnesses, before they decide what the decision should be. So this is, in a nutshell, what we should expect from tomorrow. So when you say we're going to have fireworks from tomorrow, trust me, we're going to have fireworks.
The fireworks are on.
Yes, because the parties also have preliminary objections which have been filed. Now, preliminary objections will be taken along with the substantive matters because we don't have preliminary objections determined first and then the election petitions determined after that. So we're going to have those things which are complained about on the preliminary objections taken alongside the election petition itself. And then it's a whole lot of work.
Right.
And people should not be unduly anxious. But I can assure you of one thing. When the decision is finally taken, the judges will give reasons for their decisions. So that is what people should look at the end of the day.
You've taken us through, I mean, it's quite lengthy for some of us that are not lawyers. Maybe have gotten lost in some way, but of course it gives an insight as to what to expect. And for a lot of Nigerians, because this is for Nigerians, we don't know if it will be televised yet, but at least we can prepare the minds of Nigerians for the bits and pieces that will come out. And Mr. Agbola, if you can help Nigerians understand just how big a deal this is, or otherwise, I don't know how you are seeing it.
Well, it's a big deal because anytime a presidential election result is challenged, it's always a big deal because people are anxious. A lot of people are under the mistaken impression as to how cases are conducted. This is one of the special cases where the Court of Appeal is a court of first instance. Ordinarily, the Court of Appeal does not listen to evidence. It only takes appeal from case from the High Court or court martial. But in this case, it is the one that is going to listen to the evidence by the parties and come to a conclusion. So it's going to be, it depends. This is a case that is more or less driven by the petitioner. It is what the petitioner is the one that has come to court, whether it's a Labour Party, whether it's PDP, whether it's APN. They are the one that will determine how quickly, because it's the issues resolved. I have listened to some very senior lawyers saying that, oh, this matter can be concluded before May 29, which is just about 2 weeks away. I can assure you, let us forget about that. That is not going to happen. Unless the only way those matters can be concluded before that time is see the petitioners withdraw their petition and the matter is struck out.
So what if the justices work at unprecedented speed? Is
it's not possible because, as the learned senior advocate earlier said, there are procedures. You have preliminary objections. You are going to take evidence. It is election petition is if it's only one issue. For example, the issue of whether you require to score 25% of Abuja. That one does not require current evidence. That is just issue of law. If that is the only issue, perhaps it can be concluded. You can finish presenting your case this week. But the judges will still have to consider when to deliver their judgment. And that is a matter for the judge, depending on the pressure of work they have. Because we are talking about 5 petitions. One may likely be withdrawn tomorrow. The issue really is that it takes time to listen to all the parties. No matter, there's nothing like a simple case. Because we have the Supreme Court has ruled some years ago that when you allege fraud in an election petition, you must prove it beyond all reasonable doubt. You cannot take examples. And so in Lagos, we have about 13,000 polling units.
Yes.
You must call witnesses from each polling unit.
And that's a huge burden.
That's a huge burden. So if you have 1,000 witnesses, you remember, even if it's only to stand up and mention their name and see that, you know how long that one will take. So that's why I say it's the petitioner that will determine how long this will take. So when we are talking about the process, people should not get too excited at this stage because the case, even tomorrow when you say fireworks, it will just be preliminaries. Tomorrow will just be a sort of record keeping. How do we proceed? How are we going to do it? Which one are we taking first? Because you have 4 or 5 petitions by the same tribunal. Definitely, you can't have fire because they are not going to be consolidated.
But they want to make an impression. The lawyers want to make a first impression.
The impression really at beginning of a case. Nobody is making any speech tomorrow. The only issue would be, okay, you have plenary objection. The judges the tribunal member may say likely that we are going to hear everything together with the main petition. So let us keep that one in abeyance.
I thought there was a pre-hearing, and this is the main hearing that is coming up tomorrow.
The pre-hearing is about, we want time for us to file papers.
And that has been concluded.
That has been concluded.
Right.
But now the plenary objection itself is part of the main hearing because we are challenging the hearing of the case itself. Likely, as I said, it will be taken together with the main case. So you have to call witnesses. Unless if you say you're not calling witnesses, you always say no on law. That is the only one that can be fast. But if you are going to allege fraud, you must call witnesses. You must prove it beyond all reasonable doubt.
I mean, just thinking about that alone, it's huge. But Mr. Dilola, what do we know from history about tribunals, really? Especially at this level, we've seen tribunals upturn governorship elections. We've seen them upturn, legislative elections. But what does history tell us really about tribunal? At this stage, what are the possibilities?
Let me go far back. I recall that when we had the 1979 elections, it was the first time I had the opportunity of voting. We had the issue of the 12 2/3. That was a very technical point. So technical points may also arise here that we do not anticipate. Aside from that, the council representing these parties, without a doubt in my mind, are very well qualified people, experienced in election petitions. And so everyone must dig deep and try to unravel something which is peculiar. It's not going to be run-of-the-mill. So like I said, in the days when we had the Awolowo versus Shagari election petitions, of course, a lot of people who were the UPN supporters expected that we were going to have the runoff. It didn't happen. So I'm not going to anticipate anything here because I do not know what the council are going to be, the council representing the respective parties are considering. But if we go beyond that and then we talk about even the recent elections, the current president was a participant in 4 elections before he became president. And on each occasion, he felt he had done his bit. He felt he had all the votes that he needed, but he didn't become president. The Election Petition Tribunal will listen to evidence. We look at also documentary evidence, and that's a lot. They've got a lot of documentary evidence to consider. And when that happens, the outcome will be based upon the evidence and the oral evidence and documentary evidence. Like my learned colleague has just said, the petition presented before them, supported by the evidence, can only be limited to the amount of time given to them. If we have, for example, witnesses from 174,000 polling units that we had, we would never finish. So election petitions require a lot of tact, require a lot of resources on the part of the council, but most importantly, with a presidential election, let's be frank here, it's an uphill task. Uphill task because for you to demonstrate that the winner has not won, you must prove one of 3 things. 1, that he wasn't qualified to even contest. 2, that he didn't win the majority of the votes. Or thirdly, that the electoral guidelines were not substantially complied with. And how do you demonstrate that? So over time, that is what we have had. It is easier when you're discussing or you're talking about election petitions at the governorship level where you're talking about a small state. But when it's the presidential election, I'm going to watch everything going on, and I tell you for free that I'm going to be seeing everything that's going on because I want to see what every council is going to be putting on the table for us to see, which is peculiar to what we have seen in the past. Or more than anything else, like my learned colleague has said, the petition as presented will determine more than anything else.
I wonder if you want to add to that, especially what history tells us. But you made a point about you would follow up. Would you want it to be televised? I don't know, both of you. Would you want it to be televised?
I don't think we should reduce the court process to a television spectacle. Our courts are rather conservative when it comes to the issue of televising or even allowing the use of even still photography in court. It's only an exceptional circumstance. And in my opinion, the lawyers, with all due respect to them, some of them will start playing to the galleries when they have camera. The issues, perhaps we may wait until the judgment, that if the judgment can be televised. But when it comes to the humdrum of presenting evidence, it can be very boring for those of us who go to court every day. It's very little time that is exciting. A lot of times it's things we have gone through so many times. We are calling witnesses. Some of them may not be available. Some of them may be sick. Some of them may collapse in the middle of the giving of evidence. Those are not the kind of things we want to see.
I think the Nigerians, especially people who have called for it, might not just mind. I don't know if you agree with him on this.
Well, I'll differ for these reasons. First of all, the Code of Conduct Tribunal, if you recall, was televised to an extent. When the former Chief Justice of Nigeria was appeared before them, it was televised. Then we also have the Oputa panel, which wasn't exactly a court, as such. It was televised. What it might just do is it might give citizens who think that they just want to see exactly what is going on an opportunity to observe the proceedings. Maybe, just maybe at the end of it all, it might give them an opportunity to say, well, at least justice was served.
Might give them confidence in the judiciary.
It might be a question of perception. And I think that in the situation in which we are, I think a lot of people want to be convinced that, well, if my candidate didn't win, at least let me see that justice has been served. Yeah.
Clearly, you don't agree with that, but let's talk about the point you made about this being a very arduous task. And I had to go through that tautology just to show that it's a huge one. Maybe what is now is not what should be. And I think that's a conversation or a debate that we're beginning to see now. People saying, well, that duration doesn't quite work, especially because it will be difficult to upturn an election of a president that is sitting. It has never been done before in that sense. Is now the time for that conversation? Is now really a time to have that debate? Maybe that can help also in helping people accept the process.
Well, I would rather say I'm looking forward to the time when challenge to elections will not be a matter for the courts. Right now, the election petitions is really destroying the integrity of the courts and the time available for other litigants. We are spending too much time on election petitions. When you look at the issue of limiting the time, we've had elections overturned before under the old electoral law, 3 years after somebody has served as governor.
That's the one that concerns the current presidential candidate of Labour Party?
Yes.
When he was governor?
Yes. So the problem, that is why people canvass that we should limit the time when elections petitions are had, so that somebody will not take undue advantage of being a fraud on the seat. So the argument cuts both ways when you look at the time limit. But the issue really is that election petition we call it sui generis. It's a special form of litigation. It's not the ordinary one. A lot of things go on there that are not normally present in the normal court system. So what we need to do really is a situation where we can clean up our act, that people will be more willing to accept election results as declared, rather than everybody going to court for every little infraction. Because I've seen some of the people that have gone to court, and I said, what is the hope? We have people who are number 10 or number 12 coming to court to challenge, to obtain the result of an election. And I said, we have to change, the politicians really have to change their mindset. And then we also do not want a situation where somebody just said, let me just win at whatever cost. since the likelihood of it being
might not be overturned anyway.
Exactly.
But, you know, the politicians will say it's the people's mandate. The people gave me this mandate. It was stolen from me, so I need to get it back. But even if it were to be decided before May 29th, there's still another level of appeal, the Supreme Court, right?
That's
so
right.
does it still make, I mean, they can go to the Supreme Court and that might take a longer time. So saying it should be done before May the 29th, is it feasible? Because there's still another level, the Supreme Court.
It's not feasible, clearly. So, to start with, if anyone wanted us to finish with the election petitions before the 29th, that means those who filed the petitions should not have exhausted 21 days in filing. They probably should have filed 2 days after the results were announced. Then the other party can then be told, well, because the petitioner filed within 2 days, file your response within 2 days as well.
But you remember there was that controversy about the beavers inspecting the beavers and all of that, which they said, well, took them extra time. They had to even go to court on that particular one.
That's great. So there we go. So that was not their fault. That was not the fault of the respondent. So who's going to pay for that? So we shouldn't be in a rush. But one thing I can tell you is, if at the end of the day, the decision goes this way or that way, it gives us an opportunity to review the Electoral Act again. That document should be a dynamic one, an organic document,
right,
until when we finally get it right. Otherwise, we should be ready to move back the date of the primaries and move back the date of the election, so that by the time we're done, we have elections, maybe, for example, in September. By the time we are done, then we're ready for May 29th.
Very interesting proposition, but final words. Just one sentence from both of you. How you expect Nigerians to handle this, and the political players, how you expect them to conduct themselves outside of a court. I'll start with you, sir.
Yes, thank you. My appeal to the politicians and the general public is that they should invest their trust in the judiciary, that they are working under extreme conditions, and they should trust the system. You cannot, when you go to court, somebody is going to lose. That is just it. Okay. So whoever loses should accept it. If they want to appeal, of course, they have the right to do so. But people should not start inputting other motives behind the judgment.
Right. Mr. Dilola, final words.
Well, I'll agree with my learned colleague, but I just add that everyone should begin to realize that we cannot burn down our country because elections have not gone our way. Someone's going to win at the end of the day when the election tribunal finishes. It might just be the winner today, the president-elect, who might be told, oh, well, you haven't won, so get up from the seat. It might be the one who has come second who might be told, but whatever the decision is, just like my learned friend has just said, let us accept the result, and then we have a duty to speak to those who represent us in the National Assembly to see how some of these things can be amended to ensure that we have less room for controversy.
And it's not rocket science, is it?
It isn't rocket science.
Well, I definitely enjoyed this session. It makes me feel like studying law, but maybe too late in the day. I'd like to thank you so much, gentlemen. Mr. Kayode Adelola, Senior Advocate of Nigeria, as well as Mr. Adeleke Agbola, also Senior Advocate of Nigeria. Thank you so much for your time.
Thank you very much.